typically when someone is convicted of a regular DUI, not a reduced charge, it's typically a 3-year probation. It can be 3 to 5 years. But if this happens in San Francisco or the San Francisco Bay Area, any of the surrounding counties, once your probation is over, once the 3 years of probation is over, you can get your attorney to make a motion to the court to expunge the record. And by doing so, once the court has signed off on it, and then the DA may contest it, but anyway, once we get the court to agree to the expungement, and that's based on typically you having complied with all the conditions of probation, paid your fine, done your DUI school, whatever you had to do, then under Penal Code Section 1203.4, an expungement will be granted by the court in most cases, and that will basically dismiss the DUI case so that you can say that to a potential employer that you don't have a DUI. You can say that you don't have a DUI conviction. You can also, for many purposes, have a clean record unless it's for certain things. And that one of those things would be a professional license. Now in California, they give out approximately 300 professional licenses, and this can be for real estate. This can be for, medical field. This can be for different types of professional business licenses, working in the financial industry. For those licenses, you would still have to reveal that you did have a DUI conviction, even though it's been expunged. An expungement is not a seal and destroy. It doesn't wipe it clean. What someone would see if they had your record run is that they would probably see the arrest, the conviction, but then they would see the dismissal of the case, which is the most important thing, which means you do not have a conviction. Now, that does not clear things up for priorability. And what priorability is if you get a second DUI in California within 10 years, that first one will count as a second offense, and the penalties are greatly increased. The potential penalties are greatly increased. So it will still, for say you had a DUI in Marin County or Alameda County or San Mateo County, Napa, wherever, and then you pick up a DUI in San Francisco, and even if it's been past the period of probation, that the 3 years is up, and we've gotten an expungement for you, you are still subject to the priorability for the first one. So even though it's been dismissed for purposes of the new case, the new DUI case, that would still be charged most likely as a second offense. Something that's really important to know about expungements, in the San Francisco Bay Area or any county in California, is that if we can get charges reduced to an offense that only carries a 1-year probation, something like a wet reckless, which is a lesser charge to a DUI, probation would be for 1 year, and then we could get the expungement after 1 year instead of 3 years with a DUI. And that way we can clean up the record, get the court to dismiss the conviction that much sooner.